Hey, what's up, Mom? We just got some new stuff in here. Yes, it's a lot, but we're going to go over it just like a gist of it. Hey, I am Queen Newton. Charlotte, what's up, Mama? Hello, ladies. I know it's really like late in the AM on the East Coast. It is 1:11 a.m. Y'all know me. I'm crazy. And I come out when I can come out. And I see my brother Atmos has been working his thing. He's been doing his thing. And people are still retarded in these streets. Lord. Now that Bill Cosby's free, everybody's like a maniac. It's crazy. It's crazy how people just reacting. Like R. Kelly gonna be free tomorrow. Hello, Unique. What's up, mama? I'm chewing gum. So if y'all hear me like and doing all that, excuse me. You know I'm doing my thing. So, guys, um, there was a new order motion, whatever you want to call it, that came in today. By the way, let me know you guys can hear me loud and clear. Give me a thumbs up or a one in the chat, please. Miss Lady T, what's up, baby? Can you guys hear me okay? Do I sound too loud? All right. Thank you, guys. Now, as you can see, I hope you guys can see my screen good too. Um, okay. Okay. Just making sure you guys can hear me, see me. Everything's good. Okay. Now, this is the government and the defense made a response to the February 9th, 2021 order. Now, it says, Dear Judge Donnelly, pursuant to the court's February 9, 2021 order, enclosed, please find the parties. Joint proposed jury charge. The jury charge and verdict form in the above referenced matter, with the following exceptions to the joint nature of the jury charge. Defense counsel objects to two of the requests set forth in the jury charge and proposes alternate language, to which the government objects. A copy of their request is enclosed, and it is respectfully submitted by Jacqueline Kaulus, Kasulis. She's the acting United States attorney. Now, the jury charge Hold on. Where's the it had it set up. Okay. So now you're asking, what is a jury charge, right? So a jury charge is at the end of the trial, the judge asks the lawyers to give the court their request to charge. Now, the court charges the jury with the law in New York. Now, what that really means is that the judge gives the jury instructions on the law and definitions of what the law means. Now, before doing that, each side has an opportunity to give the court specific parts of the law that they believe are important for the purposes of either presenting or defending the case. Now, based upon the different requests, the court will then have a conference with the attorneys that is held behind closed doors in the judge's chambers with a court stenographer present. Now, the court makes rulings of law and decides which sections of the law he will use to explain to the jury. So each attorney then makes a record of any objections to the court's rulings, which may ultimately form the basis of an appeal. So basically, the jury charge is just the government and throwing down the law and what they should be basing their decisions on. So I have a little example of that. And after the closing arguments, it says that a jury charge is when it says, ladies and gentlemen of the jury, after the closing arguments, you will go to the jury room to decide the case. Answer the questions that are attached and reach a verdict. You may discuss the case with other jurors only when you are all together in the jury room. So it tells you that basic part. And then it also gives you instructions on, that you can't discuss the case with anyone else and so forth, right? Atmos went over that with the juror questionnaire, right? So we know that they're not allowed to look up certain words. They can't go on the internet. They can't speak to anybody about the case. And that they can't share experiences with other jurors or anything like that. And that they can't use phones or any other electronic devices during their deliberations. And things of that nature, right? Okay, so we got that all out the way. So the jury charge is just basically letting you guys know that this is what rules you guys have to go by, and these are the laws that are being presented. These are the rules and the laws that you should go by, and this is how you should look at this evidence. These are the things that you will look at. This is this law and that is that law. So it breaks it down like that. Let me see now. Where was the other? Okay. So that was the first one. Now here is the second one. you guys can see that good. Let's see if I can make it that big. Should I? Or is it too big? Wait. Yeah, I think that's good. All right. All right. Now this is the second part to what was downloaded today. And it is the government's request to charge. Right? So this is the United States Attorney's request of what needs to be mentioned to the jurors and what kinds of things are necessary for the trial. Well, that's a good question, Charlotte. She said that after all this time, do you think any of the jury will not know about his case considering how social media is? Well, that's a good question because, you're right. Social media is everywhere. People are using it all the time. But that's why they made that jury questionnaire the way they did. That's why the jurors are not allowed to be on social media if they did have social media. But 9 out of 10 times, they're going to pick jurors who don't have social media. They're going to pick people who don't know anything about this case, period. Because it has to be a fair trial. So that's why when they gave out those jury questionnaires, they have to answer certain questions. And that's why they made certain questions the way they were in different ways. They asked one question this way and then asked that same question in another version to try to trick you to see if you were going to lie. That's what that's about. What's up, Angie? So I think that they're going to do a fair trial. That's what the jury questionnaire is all about, to separate who's going to stay and who's going to go, who's going to be worthy of being fair, who's going to judge their peer and be fair. Look at the evidence, the testimonies, statements, evidence, exhibits, whatever it is that's needed to prove his guilt or prove his innocence. So now it says, preliminary statement. Pursuant to Rule 30 of the Federal Rules of Criminal Procedure, the government respectfully requests that the court include the following instructions in its charge to the jury. In addition, the government requests leave to offer additional instructions as they become necessary during the course of trial. The government respectfully requests that copies of the third superseding indictment, the indictment, and the jury instructions be provided to the jurors during their deliberations. So the government's saying that they need to have copies of the third superseding indictment, which is the indictment they're going by. Right? Now remember, this is for New York. And the jury instructions be provided to the jurors during their deliberations. So when they're in the room making their decisions and talking about what they're going to give him, guilty or not guilty, they're going to be going over the evidence and they're going to be going over the indictment. So the government is saying that they have to have this. Now, it says request number 1. So this is one of the requests, and it's a general request. It says that the government respectfully requests that the court charge the jury in its usual manner on the following subjects. So this is something that's normal, that happens. This is a process. A, the role of the court and the duties of the jury. B, equality of the parties before the court. C, jury communications with lawyers and the court. D, presumption of innocence. E, burden of proof and reasonable doubt. F, circumstantial evidence and direct evidence. So they will be going, they have to look at both. G, function of the indictment and what is not evidence. H, permissible inferences drawn from the evidence. I, stipulations and objections. J, charts and summaries. K, testimony of law enforcement witnesses. L, discrepancies in testimonies. M, no inference to be drawn from defendant's failure to testify, if applicable. N, testimony of the defendant, if applicable. O, dates approximate. P, deliberations. Q, the word and means or in indictment. So they're letting you know as well, the language. So the word and usually means or when you're reading the indictments. R, right to see exhibits and have testimony read during deliberations. So they have to see the exhibits and all that. S, questioning wisdom of law and basing verdict on sympathy or prejudice, prohibited, and verdict must be unanimous. So, questioning wisdom of law and basing verdict on sympathy or prejudice is prohibited. Right? Request number 2, the indictment. Hey, DJ Amazing, what's up? Request number 2, indictment. The defendant is formally charged in an indictment. As I instructed you at the outset of this case, an indictment is a charge or accusation. The indictment in this case contains 9 separate counts, on each of which you will be called upon to render a separate verdict. So they're going to have to deliberate on each charge and give a verdict, guilty or not guilty, for each charge. And like they said, there's 9 counts. So request number 3 is knowingly and intentionally. So all of the charges implicate the concepts of knowledge and intent. So as a general rule, the law holds individuals accountable only for conduct in which they intentionally engage. Thus, before you can find the defendant guilty of crimes charged, you must be satisfied he was acting knowingly or intentionally. Now, a person acts knowingly if he acts voluntarily and intentionally, not because of ignorance, mistake, or accident. A person acts intentionally if he acts with the specific intent to do something the law forbids. So the person need not be aware of the specific law or rule that his conduct may be violating, but he must act with the specific intent to do whatever it is the law forbids. Okay? So it doesn't matter if he thought he made a mistake, he wasn't sure, he didn't know, he didn't realize. No, it ain't none of that. The issues of knowledge and intent require you to make a determination about a defendant's state of mind, something that really can be proved directly. A wise and careful consideration of all the circumstances before you, however, may permit you to make a determination as to a defendant's state of mind. Now, indeed, in your everyday affairs, you are frequently called upon to determine a person's state of mind from his words and actions in given circumstances. You are asked to do the same here. Okay. Request number 4. Hey, Dana. What's up, puppy? Robert's coming home. Hey, that's what you say. That's what you say. Number 4. Aiding and abetting and willful causutation. Causutation. I guess, willful intent, right? Many of the racketeering acts in count 1 and certain of the other counts charge the defendant with aiding and abetting or willfully causing certain crimes. It is not necessary to find that the defendant personally committed those crimes as long as the government proves that he aided and abetted or willfully caused another person to do so. So even if he didn't personally do it himself, even if he had other people helping him, he still has to be accountable for that. That's what that means. So that's what they want you to look at. And it says, this is so because under the law, a person who aids or abets or willfully causes another to commit an offense is just as guilty of that offense as if he committed it himself. So with regard to aiding and abetting under federal law, the aiding and abetting statute is Title 18 of the United States Code, Section 2A, which provides that whoever commits an offense against the United States or aids or abets or counsels, commands or induces or procures its commission is punishable as a principle. So therefore, you may find the defendant guilty of an offense charged if you find beyond a reasonable doubt that the government has proven that another person actually committed the offense with which the defendant is charged. and that the defendant aided or abetted that person in the commission of the offense. So, like I said, even if he had other people acting on it, he's still accountable for it. Aiding and abetting. Now, in order to find the defendant guilty of aiding and abetting a crime, you must find that some person did actually commit the crime charged. Obviously, no one can be convicted of aiding or abetting the criminal acts of another if no crime was committed by the other person in the first place. But if you do find that a crime was committed, then you must consider whether the defendant aided or abetted the commission of that crime. So, in order to aid or abet another to commit a crime, it is necessary that the defendant knowingly associate himself in some way with the crime, and that he participate in the crime by doing some act to help make the crime succeed. So, to establish that the defendant knowingly associated himself with the crime, the government must establish that the defendant knew and intended that the crime charged would be committed. So, to establish that the defendant participated in the commission of the crime, the government must prove that the defendant engaged in some affirmative conduct or overt act for the specific purpose of bringing about that crime. So, even if he planned it and he had other people helping him, he's assumed as into committing the crime. Now, the mere presence of the defendant where a crime is being committed, even coupled with knowledge by the defendant that a crime is being committed, or merely associating with others who were committing a crime, is not sufficient to establish aiding and abetting. So, one who has no knowledge that a crime is being committed or is about to be committed, but inadvertently does something that aids in the commission of that crime, is not an aider and abetter. An aider and abetter must know that the crime is being committed and act in a way that is intended to bring about the success of the criminal venture. To determine whether the defendant aided and abetted the commission of particular crimes or caused the commission of them, ask yourselves these questions. First, did he participate in the crime charged as something he wished to bring about? Second, did he associate himself with the criminal venture knowingly and willfully? Third, did he seek by his actions to make the criminal venture succeed? So if the defendant did all these things, then he is an aider and abetter and is therefore guilty of the offense. If, on the other hand, your answer to any of these questions is no, then the defendant is not an aider and abetter, and you must not find him guilty. With regard to willful causutation, under federal law, Section 2B of Title 18 of the United States Code provides that whoever willfully causes an act to be done which, if directly performed by him or another, would be an offense against the United States, is punishable as a principle. Now, in order to find the defendant guilty of an offense charged under the statute, you must first find that another person has committed the acts constituting the offense charged. Second, you must find that the defendant had the mental state required to violate the offense charged. And third, you must find that the defendant intentionally caused another to commit the requisite act. I further instruct you that to convict a defendant of aiding and abetting or willfully causing an offense under federal law, you must unanimously agree that the government has proven beyond a reasonable doubt either that the defendant aided and abetted the commission of the offense or that the defendant willfully caused the commission of the offense. In other words, all 12 of you must agree on either aiding and abetting or willfully causing. It is not sufficient that some of you find that a defendant aided and abetted the commission of the offense, while others find that a defendant willfully caused the commission of the offense. So in other words, they all 12 of these jurors have to agree on the same exact charges, or they're going to have to go back to the drawing board. Right? All right. All right. I'm going to report you SS2. Yes. You are being reported. Every last little goddamn spam you do right now, you're being reported. Okay? So thank you for that. I see you want Robert Kelly free so bad. You know, it's okay. He might get free. He might not get free. Who knows? Let's see. If the government presents their case, and all the jurors find the evidence to be true, and they find him guilty of all charges, or they find him guilty of some charges, that's just what it is. Yeah, somebody tried to spam me. That's a fake spammer. That's just somebody pressing they fucking paste and copy. That's all that is. It's not a real spammer. It's just somebody being a dick. Pardon my French. I was trying not to curse. Okay. Sorry about that, guys. Interruption. Thank you for that, Angie. Request number 5. All available evidence need not be produced. Interesting. The law does not require any party to call as witnesses all persons who may have been present at any time or place involved in the case, or who may appear to have some knowledge of the matter in issue at this trial. Nor does the law require any party to produce as exhibits all papers and things mentioned during the course of the trial. So it doesn't, this case doesn't require for anybody to be called to the stand. Request number 6. Interviews of witnesses. Now, there was testimony at trial that attorneys for the government and the defendant interviewed witnesses when preparing for trial. So you should not draw any unfavorable inference from that testimony. So, to the contrary, the attorneys were obligated to prepare this case as thoroughly as possible and might have been derelict in the performance of their duties if they failed to interview witnesses before this trial began and as necessary throughout the course of the trial. Girl, people are crazy like that. Girl, it comes with the territory, Charlotte. You know, we got our crazies out here, girl. We normal over here, but we got our crazies. So, request number 7, uncalled witness equally available to both sides. So, both the government and the defense have the same power to subpoena witnesses to testify on their behalf. So, if a potential witness could have been called by the government or by the defendant and neither called the witness, then you may draw the conclusion that the testimony of the absent witness might have been unfavorable to the government or to the defendant or to both. So, on the other hand, it is equally within your province to draw no inference at all from the failure of either side to call a witness. You should remember that there is no duty on either side to call a witness whose testimony would be merely cumulative to testimony already in evidence, or who would merely provide additional testimony to facts already in evidence. So, either or. Okay. Right. Now, request number 8. Opinion of defendant's character, if applicable. So if it's available and it's an opinion of defendant's character, like say for instance, probably those letters that were submitted by the R. Kelly supporters, right? Now it says, the defendant has called witnesses who have given their opinion of his good character. Now, this testimony is not to be taken by you as the witness's opinion as to whether the defendant is guilty or not. So whether a jury decides to whether they do read these letters or they actually have people as witnesses to testify on the stand for his character, it doesn't matter, because you can't judge whether he's guilty or not by these references. So that question is for you alone to determine. You should, however, consider this character evidence together with all the other facts and all the other evidence in the case in determining whether the defendant is guilty or not guilty of the charges. So accordingly, if after considering all the evidence, including testimony about the defendant's good character, you find a reasonable doubt has been created, you must acquit him of the charges. So on the other hand, if after considering all the evidence, including that of defendant's character, you are satisfied beyond a reasonable doubt the defendant is guilty. You should not acquit the defendant merely because you believe him to be a person of good character. So basically, you have to just go you have to go with the evidence and what's presented and what is shown to you to be beyond a reasonable doubt that he's guilty or innocent. Now, request number 9. Uncharged acts considered for a limited purpose. Now, this is if applicable. Now, you have heard evidence that the defendant engaged in conduct, including crimes, other than the crimes charged in the indictment. The defendant is not on trial for committing any acts not charged in the indictment or for acts committed outside the time periods charged in each count of the indictment. So consequently, you may not consider evidence of those other acts as a substitute for evidence that the defendant committed the crimes charged in the case. Nor may you consider evidence of those other acts as proof that the defendant has a criminal propensity. That is, you may not conclude that he likely committed the crimes charged in the indictment because he was predisposed to criminal conduct. Instead, you may consider evidence of uncharged conduct by the defendant for limited purposes. You may consider it only for the following limited purposes, which I will now describe. So you may only consider evidence of uncharged conduct as evidence of the existence of the charged enterprise and as evidence that the enterprise engaged in racketeering activity, as evidence of the defendant's position or role within the enterprise, as evidence of the development of relationships of mutual trust between the defendant and others with whom he is charged with carrying out the charged crimes, as evidence of conduct that is inextricably intertwined with evidence of the charged crimes, as evidence enabling you to understand the complete story of the charged crimes, as evidence of a modus operandi formed by the defendant and his accomplices to commit the charged crimes, and as evidence corroborating the testimony of other government witnesses. Evidence of uncharged conduct by the defendant may not be considered by you for any purpose other than the ones I have just listed. So you got to just stick to the facts of what's being said in the case and what he's being charged with. You can't go beyond lifetime and all these other things because lifetime has nothing to do with these charges at all. You gotta, you can't, that's just an example, right? Okay. Yeah, those letters were crazy, but they might just use some of these letters in the trial to use as character references, so it might do a trick or two. You never know. It might just, make the person think, well, damn, he's a good person and this and that, but they just proved that he did this and he did that. So, those letters really don't mean anything. You know what I mean? They can't really go off of those letters. They have to just stick to the evidence. They could just say, oh, that's nice. Request number 10. Impeachment by prior inconsistent statement, if applicable. So impeachment, is to throw out, right? So inconsistent, we know, is, things don't sound right. This don't match up with that, and this don't match up with that, right? So now it says that you have heard evidence that a witness made a statement on an earlier occasion, which counsel argues is inconsistent with the witness's trial testimony. Now, evidence of the prior inconsistent statement was placed before you for the limited purpose of helping you decide whether to believe the trial testimony of the witness who contradicted himself or herself. If you find that the witness made an earlier statement that conflicts with his or her trial testimony, you may consider that fact in deciding how much of his or her trial testimony, if any, to believe. In making this determination, you may consider whether the witness purposely made a false statement or whether it was an innocent mistake, whether the inconsistency concerns an important fact, or whether it had to do with a small detail, whether the witness had an explanation for the inconsistency, and whether the explanation appealed to your common sense. It is exclusively your duty, based upon all the evidence and your own good judgment, to determine whether the prior statement was inconsistent, and if so, how much. If any weight should be given to the inconsistent statement in determining whether to believe all, part, or none of the witness's testimony. Request number 11. Jury is to consider only defendant on trial. You have heard evidence about the involvement of certain other people in the crimes charged. You may not draw any inference, favorable or unfavorable, towards the government or the defendant from the fact that certain persons are not on trial before you. So that these other individuals are not on trial before you is not your concern. You should neither speculate as to the reason these people are not on trial before you, nor allow their absence as parties to influence any way your deliberations in this case, nor should you draw any inference from the fact that any other person is not present at this trial. Your concern is solely the defendant on trial before you. So you can't look at anybody else but the defendant, okay? Because it's him that's on trial, nobody else. Request number 12. Expert testimony. You have heard the testimony of what we call expert witnesses in this case. Ordinarily, witnesses are restricted to testifying concerning matters of fact. There are occasions, however, when there is some technical or other specialized area of knowledge that will assist the jury in deciding a disputed fact. On those occasions, a witness who is specially qualified by training, knowledge, experience, or education may be called to testify about some evidence or facts in issue in the form of an opinion. Now, in weighing expert testimony, you may consider the expert's qualifications, the opinion given, the witness's reasons for testifying, as well as all the other considerations that ordinarily apply when you are deciding whether or not to believe a witness. So you may give expert testimony whatever weight, if any, you find it deserves in light of all the other evidence before you. You should not. However, accept a witness's testimony merely because he or she is an expert in a field, nor should you substitute it for your own reason, judgment, and common sense. The determination of the facts in this case rests solely with you. In short, the opinion of an expert witness is in all respects the same as the testimony of any other witness. Give it such weight as you think it deserves. So you ain't really got to listen to the experts either. You go with what you feel, with your better judgment and common sense and an open mind. Request number 13. Particular investigative techniques not required. You have heard reference in the arguments of defense counsel in this case to the fact that certain investigative techniques were not used by the government. There is no legal requirement, however, that the government prove its case through any particular means. While you are to carefully consider the evidence adduced by the government, you are not to speculate as to why they used the technique they did or why they did not use other techniques. The government is not on trial. Law enforcement techniques are not your concern. Your concern is to determine whether or not, on the evidence or lack of evidence, the defendant's guilt has been proved beyond a reasonable doubt. So, again, you must just concentrate on the case. Don't worry about what techniques the cops did to draw people in, or XYZ or XYZ, why they gave a plea to this guy and a plea to that guy, why they bailed this one out and why they didn't let this one out. That's not of any concern. Request number 14, venue. Now, venue refers to the location of the charged crimes. So each count of the indictment alleges that the crime charged occurred in whole or in part in this judicial district, which is the Eastern District of New York. Now, remember, my lawyer friend said, Miss Esquire said that the reason why they brought the charges to New York is because some of these crimes happened in New York. Okay. So this district includes Brooklyn, Queens, Staten Island, Nassau, and Suffolk counties on Long Island. Now, apparently, what happened with Faith Rogers, something happened with her in Long Island, if I'm not mistaken, right? Okay. And the waters surrounding Manhattan. So to establish a venue for a crime in this district, the government must prove that some act in furtherance of the crime happened in the Eastern District of New York. Now, with respect to count 1, the racketeering count, the government need only prove that some act in furtherance of the racketeering offense happened in the Eastern District of New York and need not prove that any or all of the alleged racketeering acts happened in the Eastern District of New York. So, in other words, all they really need is one offense, one of them that happened in New York. Unlike the other elements, the government must prove venue only by a preponderance of the evidence. That is, it is more likely than not that some act in furtherance of the crimes occurred in Brooklyn, Queens, Staten Island, Long Island, or the waters surrounding Manhattan. Request number 15. Count 1. Racketeering. Now, count 1 of the indictment charges the defendant with violating the Racketeer, Influenced, and Corrupt Organizations Act. Count 1 reads as follows. In or about and between January of 1994 and the present, both dates being approximate and inclusive within the Eastern District of New York and elsewhere, the defendant Robert Sylvester Kelly, also known as R. Kelly, together with others being a person employed by and associated with the enterprise, an enterprise that engaged in and the activities of which affected interstate and foreign commerce, did knowingly and intentionally conduct and participate directly and indirectly in the conduct of the affairs of the enterprise through a pattern of racketeering activity as defined in Title 18, United States Code Section 1961 1 and 1961 5, consisting of the racketeering acts set forth below. Now, the relevant provisions of the racketeering statute reads as follows. It shall be unlawful for any person employed by or associated with any enterprise engaged in or the activities of which affect interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprises' affairs through a pattern of racketeering activity. To prove this crime, the government must prove 5 elements beyond a reasonable doubt. The rest of the enterprise is managers, bodyguards, entourage, stuff of that nature. And right now they have Richard Arline, Michael Williams, Don Russell, Daryl McDavid, and Jim Brown as 5 of the people who are part of the enterprise who were also indicted. So now, to prove this crime, the government must prove 5 elements beyond a reasonable doubt, right? The first thing they must prove is an enterprise, as described in the indictment, existed on or about the time alleged in the indictment, right? 2, the second thing is the enterprise engaged in or its activities affected interstate or foreign commerce. 3rd, they must also prove beyond a reasonable doubt that the defendant was employed by or was associated with the enterprise. And we all know that he's actually the CEO of the enterprise, right? Fourth, the defendant knowingly conducted or participated either directly or indirectly in the conduct of the affairs of the enterprise. And fifth, the defendant knowingly participated in the conduct of the affairs of the enterprise through a pattern of racketeering activity as described in the indictment. That is, through the commission of at least two of the charged racketeering acts, the last of which must have occurred within 10 years after the commission of a prior racketeering act, or through causing or aiding and abetting the commission of two such racketeering acts. I will now explain each of these elements in greater detail. Hey, Sharice, what's up, mommy? Hey, Karen Johnson. Now, first element, the existence of the enterprise, right? Now, the first element, the government must prove beyond a reasonable doubt is that an enterprise existed, right? Now, the indictment alleges the existence of the following enterprise, right? Now, it says alleged, right? Everything is alleged. Okay. The enterprise. 1. The defendant Robert Sylvester Kelly, also known as R. Kelly, and individuals who served as managers, bodyguards, drivers, personal assistants, and runners for Kelly, as well as members of Kelly's entourage, comprised an enterprise. The enterprise, within the meaning of 18 U.S.C. 1961-4, that is, the enterprise constituted a group of individuals associated in fact that was engaged in and the activities of which affected interstate foreign commerce. The enterprise constituted an ongoing organization whose members functioned as a continuing unit for a common purpose of achieving the objectives of the enterprise. Ty! The purpose of the enterprise were to promote R. Kelly's music, right? Oh, wait, sorry. Let me go back. Okay. 2. The purposes of the enterprise were to promote R. Kelly's music and the R. Kelly brand, to recruit women and girls to engage in illegal sexual activity with Kelly, and to produce pornography, including child pornography. By promoting R. Kelly's music and the R. Kelly brand, the members of the enterprise expected to receive financial opportunities and personal benefits, including increased power and status within the enterprise. In connection with the enterprise, 3. In connection with the enterprise, Kelly and other members of the enterprise traveled throughout the United States and abroad to perform at concert venues, to promote the R. Kelly brand, and to recruit women and girls to engage in illegal sexual activity with Kelly. 4. When Kelly attended and performed at concerts and other events, Kelly and or members of the enterprise on Kelly's behalf invited women and girls backstage and to other events following Kelly's live performances. These women and girls were often offered wristbands that signified that they were authorized to attend an event. There, Kelly relied upon members of the enterprise to ensure that only those authorized to attend were allowed at the event and to manage the flow of women and girls who were directly interacting with Kelly. Now, 5. When Kelly identified a woman or girl who he wished to see again, he either gave his contact information to the woman or girl, or obtained her contact information, or relied upon members of the enterprise to do so. Following these events, Kelly communicated with certain of these women and girls by telephone, including through the use of traditional telephone calls, text messages, iMessages, and FaceTime. As part of this communication, Kelly often requested that the women and girls provide him with photographs of themselves. Number 6. Kelly and other members of the enterprise also arranged for the women and girls to travel to see Kelly on occasion, including at concerts throughout the United States and related events. To facilitate their travel, Kelly directed the women and girls to contact a member of the enterprise, who then arranged the travel for the women and girls. When the women and girls arrived at the lodging, which was typically selected by a member of the enterprise, a member of the enterprise usually provided them with instructions. In addition, members of the enterprise took steps to ensure that the women and girls did not interact with other women and girls whom Kelly planned to see. Members of the enterprise then arranged for the women and girls to attend his concerts and positioned them such that Kelly could see them during his concerts. Number 7. Kelly promulgate promulgate I can't even pronounce that. Promulgated numerous rules that many of his sexual partners were required to follow, including the following. A. The women and girls were not permitted to leave their room without permission from Kelly, including to eat or go to the bathroom. B. The women and girls were required to wear baggy clothing when they were not accompanying Kelly to an event or unless otherwise instructed by Kelly. C. The women and girls were not permitted to look at other men and instead were told to keep their heads down. And D. The women and girls were required to call Kelly daddy. 8. The enterprise operated within the Eastern District of New York and elsewhere, including overseas. Now, the methods and means of the enterprise. Granny! Among the means and methods by which Kelly and his associates participated in the conduct of the affairs of the enterprise were the following. So this is going to go through what they see as the methods and means of the enterprise. A. Committing, attempting, and aiding and abetting the commission of crimes and conspiring to commit crimes, including but not limited to engaging in sexual activity with girls under 18 years old. Engaging in and facilitating sexual activity without disclosing a sexually transmitted disease Kelly had contracted. Producing child pornography, bribery, extortion, coercion, and blackmail. B. Demanding absolute commitment to Kelly and not tolerating dissent. C. Obtaining sensitive information about sexual partners and members and associates of the enterprise to maintain control over them. D. Creating embarrassing and degrading videos of sexual partners to maintain control over them. E. Recruiting and grooming sexual partners for Kelly. And F. Isolating women and girls from friends and family and making them dependent on Kelly for their financial well-being. The term enterprise as used in these instructions may include any group of people associated in fact, even though this association is not recognized as a legal entity. Thus, an enterprise need not be a formal business entity such as a corporation, but may be merely an informal association of individuals. Oh, you see, so that's why they're labeling him as an enterprise. Because an enterprise need not be a formal business entity, such as a corporation, but may be a merely an informal association of individuals, like his entourage. You know, his entourage is his peoples, right? They might not be getting paid, but they're associated with him, and he's associated with them. So that forms an enterprise, even though it might not be a business one. It just might be formal. Business would be his managers and his bodyguards and his assistants, right? So the term enterprise includes legitimate and illegitimate enterprises. So an enterprise can be a vehicle used by a defendant to commit crimes. So an enterprise can be a vehicle, guys. A vehicle used by a defendant to commit a crime. So if John Doe went and committed a robbery and used two people with him and used the car, they are now an enterprise. You know what I mean? Including the vehicle. They used the vehicle as well to commit this crime. This car is associated with the enterprise. So the enterprise does not have a particular name, or for that matter, any name at all, nor must it be registered or licensed as an enterprise or be a commonly recognized legal entity such as a corporation, a partnership, a business, or the like. A group or association of people can be an enterprise. Now, if these individuals have associated together for a common purpose of engaging in a course of conduct, mere similarity of conduct, or the fact that individuals may have assembled together and discussed common aims and interests does not necessarily establish proof of the existence of an enterprise. Though you may consider such factors, such an association of persons may be established by evidence showing an ongoing organization, formal or informal, and by evidence that the people making up the association functioned as a continuing unit. The government must prove an association in fact enterprise existed by evidence of an ongoing organization, formal or informal, and by evidence that the various associates functioned as a continuing unit. And the enterprise must have the three following structural features. 1, a purpose. 2, relationships among those associated with the enterprise. And 3, longevity sufficient to permit these associates to pursue the enterprise's purpose. So even the length of time he's been doing it. It is not necessary that the enterprise have any particular or formal structure, but it must have sufficient organization that its members functioned and operated in a coordinated manner in order to carry out the alleged common purpose or purposes of the enterprise. So every time he sent somebody to go get somebody food, every time he sent somebody out to go get the cars, every time he sent somebody out to go drive somebody somewhere, that they're part of the enterprise. Their common purpose was to help R. Kelly with his business, flowing the girls, flowing the music, flowing the concerts, flowing his merch and things of that nature, as well as recruiting girls. Now, what was I? Now, such a group need not have a hierarchical structure or a chain of command. Decisions may be made on an ad hoc basis and by any number of methods: by majority vote, consensus, a show of strength, etc. Members of the group need not have fixed roles. Different members may perform different roles at different times. The group need not have a name, regular meetings, dues, established rules and regulations, disciplinary procedures, or initiation procedures. Now, while the group must function as a continuing unit and remain in existence long enough to pursue a course of conduct, you may nonetheless find that the enterprise element is satisfied by finding the existence of a group whose associates engage in spurts of activity, punctuated by periods of inactivity. So, thus, an enterprise need not have role differentiations, a unique modus operandi, a chain of command, sophistication of organization, diversity and complexity of crimes, uncharged or additional crimes aside from the alleged racketeering activity, or an enterprise name. So, moreover, an enterprise is not required to be businesslike in its form or function, and it may, but need not, have an economic or profit seeking motive. It doesn't matter if they were making profit or not, it was still illegal activities going on, allegedly, right? So, indeed, RICO is not limited to groups whose crimes are sophisticated, diverse, complex, or unique. Now, such an association of individuals may retain its status as an enterprise, even though the membership of the association changes over time by adding or losing individuals during the course of its existence. Now, the existence of the enterprise continues even if there is a gap or interruption of the enterprise's racketeering activities. Now, although whether an enterprise existed is a distinct element that must be proved by the government, common sense dictates that the existence of an enterprise is oftentimes more readily proven by what it does rather than by an abstract analysis of its structure. So, thus, the evidence used to prove the pattern of racketeering and the enterprise may coalesce. Therefore, you may consider proof of the racketeering acts to determine whether the evidence establishes the existence of an enterprise. And further, you may infer the existence of an enterprise from evidence of the pattern of racketeering activity. I am reading what they call the jury charge, Granny, which is where the government lays down the rules for the jury and advice as to how they should go about their deliberations at the end of the trial. What to look up to, what to consider as evidence, what not to consider as evidence, what witnesses to take serious, what witnesses not to take serious, things of that nature. And they also break down the indictment here for the jurors to understand what they're reading when they do get the indictment, and they read through it themselves when they're going back into the room for deliberations. So this is basically what this is for. This is a list of things that they must abide by. I'm sorry. So that's what I'm reading here. So the government is not required to prove each and every allegation about the enterprise or the manner in which the enterprise operated. So the enterprise proved, however, must be essentially the one alleged in the indictment. So whatever they prove, they have to prove what's in the indictment. Let's see here, what else? Didn't I just see, what the hell? Oh, here it is. I know it's you, Oko motherfuckers, that's dumbing down my RSK defense exercise. What? Nah, I know it's the RSK supporters. Only the supporters would thumbs down something that's... Yeah, they really do, Angie. I agree. I don't know if charge is the appropriate word. Maybe convict. I need to go check it out, Angie. Hey, Granny is Uncle. I can't make this shit up. The exercise is 100% pro. You guys are so funny. Okay, so, all right, now, how long have we been on here, guys? I was trying not to stay too long because this is actually a very long document. It's 29 pages, 89 pages. All right, we've been going for an hour and a half. All right, so I got another half an hour with you guys, and then I'm going to call it quits, okay? All right. Okay. Now, 2, the second element, which is effect on interstate or foreign commerce. Now, the second element that the government must prove beyond a reasonable doubt is that the enterprise was engaged in or had an effect on interstate or foreign commerce, even if it was only a minimal effect. Interstate commerce means trade or conducting business or travel between one state and another state or the District of Columbia. And foreign commerce means such trade, business, or travel between the United States and another country. So, therefore, interstate and foreign commerce may include the movement of money, goods, services, or persons from one state to another state, or the District of Columbia, or between the United States and another country. So, this may include, among other matters, the purchase or sale of goods or supplies from outside the United States, the use of interstate or international mail or wire facilities, or the causing of any of those things. Now, the government need not prove that the acts of the defendant affected interstate commerce or that the defendant knew he was affecting interstate commerce. So the government does not need to prove the acts of the defendant affected interstate commerce or that the defendant knew he was affecting interstate commerce. So regarding that alternative method of satisfying this element, to establish the requisite effect on interstate or foreign commerce, the government is not required to prove a significant or substantial effect on interstate or foreign commerce. This element, which simply ensures federal jurisdiction over the conduct, is satisfied if even a minimal effect on interstate or foreign commerce is shown. The effect need not be direct. Any effect, even if it is postponed, indirect, or slight, is sufficient to satisfy the interstate commerce element. So it does not matter whether the effect is harmful or beneficial to interstate commerce. Moreover, it is not necessary for the government to prove that the defendant knew that the enterprise would affect interstate or foreign commerce, that the defendant intended to affect interstate or foreign commerce, or that the defendant engaged in or his activities affected interstate or foreign commerce. I instruct you that it makes no difference whether the type of interstate commerce affected is legal or illegal. It is not necessary for the government to prove that the individual racketeering acts themselves affected interstate or foreign commerce. Rather, it is the enterprise and its activities considered in their entirety that must be shown to have had that effect. On the other hand, this effect on interstate and foreign commerce may be established through the effect caused by the individual racketeering acts. Third element, association with or employment by the enterprise. Give me 1 second, guys. I need to get a little sip of something to drink. Give me a second. Okay. So the third element, which is association with or employment by the enterprise. Now, the third element that the government must prove beyond a reasonable doubt is that the defendant was associated with or employed by the enterprise at some time during the period charged in the indictment. Now, associated with should be given its plain meaning. Associate means to join, often in a loose relationship as a partner, fellow worker, colleague, friend, companion, or ally, to join or connect with one another. So, therefore, a person is associated with an enterprise when, for example, he joins with other members of the enterprise and he knowingly aids or furthers the activities of the enterprise, or he conducts business with or through the enterprise. The defendant need not have been a member of or associated with the enterprise for the entire period of his existence, but the defendant must have been associated with the enterprise at the time he allegedly committed the crimes charged. That is, the government must prove the defendant was connected to the enterprise in some meaningful way and that he knew of the existence of the enterprise and of the general nature of its activities. Now, a person cannot be associated or employed by an enterprise if he does not know of the enterprise's existence or the nature of its activities. 4. The fourth element is participation in enterprise through pattern of racketeering. Sorry, I had to step away for a second. All right, now the fourth element that the government must prove is that the defendant knowingly conducted or participated, either directly or indirectly, in the conduct of the affairs of the enterprise. Now, this means that the defendant must have played some part in the operation or management in the enterprise, and that the defendant intentionally performed acts, functions, or duties that are necessary to or helpful in the operation of the enterprise. Thus, if the defendant participated in the operation or management of the enterprise itself, or he had some part in directing the enterprise's affairs, that would satisfy this element. In other words, all who participate in the conduct of the enterprise, whether they are generals or foot soldiers, are responsible for the affairs of the enterprise. Yes, exactly, Charisse. It's like a guide. You're correct. It's more or less like a guide, and the judge reads it to them. Now, the fifth element is pattern of racketeering activity, right? So, the fifth element the government must prove beyond a reasonable doubt is that the defendant engaged in a pattern of racketeering activity. The term racketeering activity is defined to mean the commission of certain crimes. A pattern of racketeering activity generally means the following. So, Granny, this is kind of like to help, this is like a guide to help them make the decision on deliberations when it comes down to the end of the trial and they have to deliberate, guilty or not guilty verdict. So they're kind of like telling you what you should follow, what you should listen to, what you shouldn't listen to, and so forth, and what certain things mean, certain words, terminology, and so forth. Now it says, first, the defendant intentionally committed or caused or aided and abetted the commission of two or more of the racketeering acts alleged in the indictment. Now, the last of which must have occurred within 10 years after the commission of a prior racketeering act. Your verdict must be unanimous as to which specific racketeering acts you find that the defendant committed, caused, or aided and abetted. Shortly, I will instruct you on the elements regarding each of the alleged racketeering acts. Second, the racketeering acts must have a nexus to the enterprise, and the racketeering acts must be related. So a racketeering act has a nexus to the enterprise if it has a meaningful connection to the enterprise. To be related, the racketeering acts must have the same or similar purposes, results, participants, victim, or methods of commission, or be otherwise interrelated by distinguishing characteristics and not be merely isolated events. 2. Racketeering acts may be related even though they are dissimilar or not directly related to each other. So provided that the racketeering acts are related to the same enterprise, for example, for both nexus and relatedness purposes. Now, the requisite relationship between the RICO enterprise and a predicate racketeering act may be established by evidence that the defendant was enabled to commit the racketeering act solely by virtue of his position in the enterprise or involvement in or control over its affairs, or by evidence that the defendant's position in the enterprise facilitated his commission of the racketeering act, or by evidence that the racketeering act benefited the enterprise, or by evidence that the racketeering act was authorized by the enterprise, or by evidence the racketeering act promoted or furthered the purpose of the enterprise. Third, the racketeering acts themselves either extended over a substantial period of time or posed a threat of continued criminal activity. The government need not prove such a threat of continuity by any mathematical formula or by any particular method of proof, but rather may prove it in a variety of ways. For example, the threat of continued unlawful activity may be established when the evidence shows that the racketeering acts are part of a long-term association that exists for criminal purposes, or when the racketeering acts are shown to be the regular way of conducting the affairs of the enterprise. Moreover, in determining whether the government has proven the threat of continued unlawful activity, you are not limited to consideration of the specific racketeering acts charged against the defendant. Rather, in addition to considering such acts, you also may consider the nature of the enterprise and other unlawful activities of the enterprise and its members viewed in their entirety, including both charged and uncharged unlawful activities. Then it says, I will now explain the law governing the 11 racketeering acts that the government has alleged. As a reminder, you must render separate verdicts of proven or not proven with regard to each of these alleged racketeering acts on the verdict sheet under count 1. So when they get those verdict sheets, they have to make choices for each count. All right. Number 16. Okay. Request number 16, Racketeering Act 1. Racketeering Act 1 charges defendant with bribery. Now, it reads that on or about August 30, 1994, within the Northern District of Illinois, the defendant, Robert Sylvester Kelly, together with others, did knowingly and intentionally cause another individual to promise and tender to a public officer and public employee property, to wit, United States currency, that such public officer and public employee was not authorized by law to accept, with the intent to influence the performance of an act related to the employment and function of a public officer and public employee, to wit, the creation of a fraudulent identification document for Jane Doe number 1, an individual whose identity is known to the grand jury, in violation of Illinois Criminal Code Section 533-1A and 551. Illinois Criminal Code Section 533-1A provides in pertinent part that a person commits bribery when, with intent to influence the performance of any act related to the employment and function of any public officer or public employee, he promises or tenders to that person any property which he is not authorized by law to accept. The government must prove beyond a reasonable doubt each of the following elements. First, that the person the defendant sought to influence was a public officer or a public employee. Second, that the defendant caused another person to promise or tender property to the person the defendant sought to influence. And third, that the defendant did so with the intent to influence the performance of any act related to that person's employment or function as a public officer or public employee. So the term public officer means a person who is appointed to an office which is established and the qualifications and duties of which are prescribed by statute to discharge a public duty for any political subdivision of the state of Illinois. Now, the term public employee is a person who is authorized to perform an official function on behalf of and is paid by the state of Illinois or any political subdivision thereof. Now, the term tender means any delivery or proffer made with the requisite intent. A mere offer or promise with the requisite intent is sufficient to constitute bribery under Illinois law. So I instruct you that the United States currency constitutes property under Illinois law. So I broke that down on what the bribery is all about. And then request number 17, which is Racketeering Act 2. Hey, Tune. Hey, Sky. What's up, Mama? Thank you, Mom. Now, request number 17, which is Racketeering Act 2. Racketeering Act 2 charges defendant with sexual exploitation of a child. Now, it reads, in or about between May of 1999 and October 15 of 1999, both dates being approximate and inclusive, within the Northern District of Illinois, the defendant Robert Sylvester Kelly, together with others, did knowingly and intentionally employ, use, persuade, induce, entice, and coerce a minor, to wit Jane Doe number 2, an individual whose identity is known to the grand jury, to engage in sexual explicit conduct for the purpose of producing one or more visual depictions of such conduct, which visual depictions were produced using materials that had been mailed, shipped, and transported in interstate and foreign commerce in violation of Title 18, United States Code Section 2251 and 2. Title 18, United States Code 2251 provides in pertinent part that any person who employs, uses, persuades, induces, entices, or coerces any minor to engage in any sexually explicit conduct for the purpose of producing any visual depiction of such conduct shall be punished. If such person knows or has reason to know that such visual depiction will be transported in interstate or foreign commerce or mailed, if that visual depiction was produced using materials that have been mailed, shipped, or transported in interstate or foreign commerce by any means, including by computer, or if such visual depiction has actually been transported in interstate or foreign commerce or mailed. Now, to prove the defendant committed this racketeering act, the government must prove the following 3 elements beyond a reasonable doubt. First, that Jane Doe number 2 was under the age of 18 at the time of the acts alleged in the indictment. Second, that the defendant used, employed, persuaded, induced, or enticed Jane Doe number 2 to take part in sexually explicit conduct for the purpose of producing or transmitting a visual depiction of that conduct. And third, that the visual depiction was to be mailed or transported or transmitted in or affecting interstate or foreign commerce or using a facility of interstate and foreign commerce or produced using materials that had been mailed, shipped, or transported in and affecting interstate and foreign commerce. As to the first element, the government must prove beyond a reasonable doubt that Jane Doe number 2 was less than 18 years old at the time of the acts alleged in the indictment. And the government does not need to prove that the defendant knew that Jane Doe number 2 was less than 18 years old. You heard that, right? The government does not need to prove that the defendant knew that Jane Doe number 2 was less than 18 years old. As to the second element, I instruct you that the words used, employed, persuaded, induced, and enticed are words of common usage. And I instruct you to interpret these words by using your own common sense. The words persuade, induce, and entice are, in effect, synonyms that convey the idea of leading or moving another person by persuasion as to some action, state of mind, etc., or to bring about, produce, or cause. A visual depiction includes any photograph, film, video, or picture, including undeveloped film and videotape, data stored on computer disk, or by electronic means, which is capable of conversion into a visual image, or data that is capable of conversion into a visual image that has been transmitted by any means. A visual depiction includes a digital recorded photograph or video. Now, sexually explicit conduct means, among other things, actual or simulated sexual intercourse, including genital to genital, oral to genital, anal to genital, or oral anal, whether between persons of the same or opposite sex, masturbation, or lascivious exhibition of the genitals or public area of any person. The term lascivious exhibition means a depiction that displays the genitals or public area of a child in order to excite lustfulness or sexual stimulation in the viewer. Not every exposure of the genitals or pubic area constitutes lascivious exhibition. Blah. Wait. Shit. Lascivious exhibition. In deciding whether a particular visual I'm ready to go, guys. Visual depiction constitutes a lascivious exhibition, you should consider the following questions. Whether the focal point of the visual depiction is of the child's genitals or pubic area, or whether there is some other focal area. Whether the setting of the visual depictions makes it appear to be sexually suggestive, for example, in a place or pose generally associated with sexual activity. Whether the child is displayed in an unnatural pose or in an appropriate attire, considering the age of the child. Now, whether the child is fully or partially clothed or nude, although nudity is not in and of itself lascivious, whether the visual depiction suggests sexual coyness or a willingness to engage in sexual activity, and whether the visual depiction was intended or designed to elicit a sexual response from the viewer. It is not required that a particular visual depiction involve all of the factors that I have just listed for you. The importance you give to any one factor is up to you to decide. While the government must prove that the defendant acted with the purpose of producing a sexually explicit visual depiction, the government does not need to prove that a visual depiction of sexually explicit conduct was actually produced. Now, in deciding whether the government has proven that the defendant acted for the purpose of producing or transmitting a visual depiction of sexual explicit conduct, you may consider all of the evidence concerning the defendant's conduct. Whether or not a minor consented to engage in sexually explicit conduct is irrelevant. I'm going to read that part one more time for the slow people in the back. Whether or not a minor consented to engage in sexually explicit conduct, it is irrelevant. As the consent or voluntary participation of a minor is not a defense to the charge. As to the third element of the underlying crime, I will further define what it means for a depiction to be transported or transmitted in or affecting interstate or foreign commerce, or using a facility of interstate and foreign commerce, or produced using materials that had been mailed, shipped, and transported in and affecting interstate and foreign commerce. If a visual depiction of sexually explicit conduct, as I have defined that term, is recorded or stored on a device that was made either outside the state, whether the visual depiction was made, or in a foreign country, then that is sufficient to satisfy the interstate commerce element. It is not necessary for the government to prove that the defendant knew that the device had been made outside of the state where the visual depiction was made, or in a foreign country. Doesn't matter. Request number 18. Okay, I'm going to read this last one and then we'll continue tomorrow. I'll reschedule another live. Request number 18. Okay. Racketeering Act 3. Kidnapping. Racketeering Act 3 charges defendant with kidnapping. Now, it reads that in or about and between 2003 and 2004, both dates being approximate and inclusive, within the Northern District of Illinois and elsewhere, the defendant Robert Sylvester Kelly, together with others, did knowingly and intentionally, secretly confine an individual, to wit, Jane Doe number 3, an individual whose identity is known to the grand jury, against her will, and induce Jane Doe number 3 by deceit and enticement to go from one place to another with intent secretly to confine her against her will, in violation of Illinois Criminal Code sections 510.1. Illinois Criminal Code section 510.1 provides in pertinent part that kidnapping occurs when a person knowingly, 1, secretly confines another against his will, or 3, by deceit or enticement induces another to go from one place to another with intent secretly to confine her against her will. The government must prove beyond a reasonable doubt each of the following elements. First, that the defendant acted knowingly, and second, that the defendant secretly confined or caused another to secretly confine Jane Doe number 3 against her will, or by deceit or enticement induced Jane Doe number 3 to go from one place to another place, and that when the defendant did so, he intended secretly to confine Jane Doe 3 against her will. Now, confinement is established where the victim has been clearly enclosed within something, most commonly a house or a car. Now, the secret confinement element of kidnapping may be shown by proof of the secrecy of either the confinement or the place of confinement. Put it another way, confinement is secret where it serves to isolate or insulate the victim from meaningful contact or communication with the public. That is, when the confinement is in a place or in a manner which makes it unlikely that members of the public will know or learn of the victim's unwilling confinement within a reasonable period of time. Wow. Okay, guys, we are on page 41 now, and this is where I'm going to stop. So I guess tomorrow it'll be another 2-hour live to continue reading the other 48 pages. No, Granny, we do not know minor 3, and we do not know minor 2. We know that minor 1 in New York is Aaliyah. Minor 2 is unknown, only known to the grand jury. Minor 3 is only known to the grand jury as well. She is not known in the public. Number 4, I forgot who's number 4 because they changed it. I think 4 was Azriel and 5 is or 4 is somebody else. I think 4 is I think 4 is Jerron Pace. I'm not even sure. I forgot who number 4 is. But number 5 is Az, and number 6 is Faith Rogers, I believe. I definitely need to stop talking. So you're very welcome. Time for me to take a break for sure. So we really don't know who 2, 3, and 4 are. We know Aaliyah's 1. And number 5 is Azriel, and number 6 is Faith. Now, I don't remember if it's 6 girls still or if it's 5 girls. Because I remember they changed it around, so I don't know too much about what's going on. And you're very welcome, guys. Hold on, let me get out of here. Okay. So like I said, we are going to leave it on page 41, and we will continue this tomorrow. And for those who are going to watch the replay, please make sure, guys, before you leave me, okay? Make sure that before y'all leave me today, you hit that like button. And if you are not subscribed to this channel, please subscribe. Share this video. Thank you, thank you, thank you. Get me to 200 more subscribers. Well, actually, I only need about 170 more. Come on, guys. Keep hitting that subscribe button. Get me there, y'all. Get me there. I'm almost there, guys. I'm almost there, guys. Thank you so much for subscribing to my channel. I appreciate you all. And if you like the content, you can cash at me at Diva Divine Light. You can also PayPal me at Diva Divine Light. The information is scrolling on the bottom of your screen. Your girl is more than appreciated of it. And yeah, there's a lot of things going on. There's a lot of confusion going on. Oh my God. I am at a loss for words. Jesus. Hold the wheels. Everybody is so amped that Bill Cosby's free. Now, he's not free because he's not guilty. Let's just get that clear. Let's make sure people understand that. He is not free on the fact that he was proven to be innocent. That's not the case. He was proven to be guilty. He did 3 years. He was supposed to do 10, I believe, or something like that. Right? He wound up doing 3. He got out on a technicality because the prosecutors faked that. Now, let's just hope that in this R. Kelly case, the prosecutors don't F it up. Let's really hope that they don't. Well, guys, that was a lot, right? Interesting how they break everything down for the juries to kind of understand how to make a decision at the end of the trial. They will get stuff to go over, the evidence and stuff like that. They will deliberate, and make their final decision when it comes to that time. So this is something that they are going to receive at the end of the trial. And the judge will go over these requests with them, these rules, as we can put it. They call it jury charge. So this is the jury charge. Jury charge is just basic rules to go by according to the law, and how to analyze what you're reading and the evidence you are seeing and hearing. Statements, testimonies, witnesses, all that. So this was very interesting. I'm actually glad I caught it tonight and I got a chance to read it. Yeah, this is a lot. So don't forget, guys, please hit that like button. Don't forget, y'all. I appreciate you guys. And I will definitely set up another one for tomorrow. Tomorrow, I'm not sure. Depends on what my schedule is like during the day. I would like to try to do it during the day. A lot of times there's a lot of things going on during the day too. People just jump in and shit. It's Saturday. So let's see what happens. I'm gonna try to do it for the afternoon, if anything, or maybe after dinner time. And that would be, of course, Eastern Standard Time. So thank you guys for hanging out with me. I appreciate y'all. Remember, if you like the content, hit the Sisters Cash App, Diva Divine Light. And if you have PayPal, you can PayPal me at Diva Divine Light as well. I love you guys. Peace.